potential acquisition. And for that process, in March of 2025, views of various ministries have been sought: Ministry of Environment, Health, Water Resources Unit, Land Drainage Authority, and we are on the 8th of April. The Water Resources Unit stated that it had no objection for the proposed extension of the existing cemetery. So now the planning section in my ministry is awaiting the views of the Ministry of Environment, Health and LDA prior to submitting planning views. So obviously all my colleague ministers will be looking into it in order to try to expedite matters.
Honourable First Member for Pito, you have your report.
B426, please.
Mr. Deputy Speaker, sir, I'm informed that no survey has been carried out to assess the average waiting time taken for a patient who is advised as a casualty or unsorted department for admission at the time he or she is admitted to the ward. I'm advised that the waiting time for a patient who is advised by a doctor for admission at the time the patient reaches the admission ward depends on different situations, and these are as follows. Insofar as emergency cases are concerned and that require immediate management and admission to intensive care unit or high dependency unit, admissions are not delayed. As such, the admitting doctor or the emergency physician will accompany the patient to the admission ward and hand over to the ICU or HDU doctor. For example, intracranial bleed patient, diabetic ketoacidosis patient, ectopic pregnancy patient, etc. For cases of acute ischemic stroke, patients needed thrombolysis are transferred immediately to the stroke unit at Victoria Hospital by SAMI for thrombolytic management. This process may take 30 minutes to 1 hour before admission to stroke unit. Note that the ideal time to reach the stroke unit should be less than 4.5 hours from onset of symptoms. For cases needing emergency surgery, patients are sent directly to the operation theatre where surgeons are already available to carry out the intervention. Mr. Deputy Speaker, I am further informed that delays may occur in cold and semi-urgent cases needing admissions. The waiting time depends on several factors that include the following: blood and X-ray investigations being requested prior to admission. Second, availability of beds in the admitting ward. Third, patients with special needs needing immediate attention, such as elderly people, pregnant women, disabled, and children. And fourth, the number of patients at peak time and off-peak time. I wish to inform the House that the situation prevailing in hospitals with the present government has taken note or in deplorable state. However, as a responsible government, we will not give up and will leave no stone unturned to improve the services in our hospitals for the benefit of our population. In addition, we are also looking for the ways and means to try to reinforce the manpower in these hospitals.
I wish to thank the Honourable Minister for his reply. No survey has been carried out during the past 10 years, let's say, and there is a critical time of 4.5 hours that an ischemic stroke patient should be managed. However, I find myself with a complaint from a patient dated the 2nd of May last week, which I'm sure the Minister will find it in the records of the Ministry, where the husband of the patient had an ischemic stroke, and the husband of the complainant had an ischemic stroke, got admitted at 5 a.m., was admitted in the chemotherapy ward of the hospital probably because of this way of camouflaging the waiting time in the hospital. Blood tests take 1 hour to wait for, and in case of emergency cases, it's more. The patient had to wait 9 hours so that the patient got transferred from the chemotherapy unit to the ward, and that is why there was this pilot project of a transitional ward in G2 Hospital. I wish to ask the Honourable Minister whether we could urgently try to implement a transitional ward so that patients who are on their feet, who don't need to be on the bed, can be in transition to a ward where they can wait for their prescriptions or other relevant papers. Meanwhile, other patients who have to be admitted urgently have the place, instead of being transferred to chemotherapy wards in emergency cases.
You want to answer?
Deputy Speaker, sir, I don't deny the fact there are hundreds of cases of negligence in our hospitals. And every day I have the habit of receiving dozens of people, and I look into cases personally every day in the morning, and the honorable member knows very well. Secondly, as far as the question of having a special ward to keep patients waiting there, that is, I may say that is a decision which has to be taken, a policy decision has to be taken at the level of the ministry. It shouldn't be for one particular hospital, but it has to be all the hospitals. But I can assure the House that maximum care is being taken these days, and I have no doubt that in the weeks or days or months to come, all the petty problems which have been occurring here and there in hospitals will be solved.
You have one question on this?
Monsieur le Vice-président.
We are talking about Sesou-Sagara.
Yes. Monsieur le Ministre, est-ce que vous êtes au courant qu'il y a un manque accru des personnels à l'hôpital SSRN? Et qu'est-ce que vous comptez faire pour pallier à ce manquement?
Unfortunately, for the last 10 years, no nursing officers were recruited, and there is a lack of 1,500 nursing officers and 300 doctors in our hospitals. And probably the forthcoming budget will find room to at least recruit 200 nursing officers, and probably by next week we are going to advertise in order to take doctors on contract. So I can assure the honourable member I'm aware of the problem, and that is the reason why I cannot accuse the doctors who are serving in the hospitals because they are overworked, and we have to understand their situation. But by means of by means of pleading to those doctors repeatedly, we are encouraging them to do the work in the meantime, and so that in the months to come probably we'll be having additional doctors in hospitals. I'd also like to inform the House that about 30 to 35 doctors, specialists have left the government service and they have been in the private. That is another problem for us.
Honorable Second Member for Belrose-Cadbourne.
B427.
Mr. Deputy Speaker, sir, the Belrose Fair, previously known as Doyen Fair, was originally held in the open air along the former railway track at Avenue Doyen, Belrose. Following the implementation of the Metro Express project, the fair was relocated on 15 September 2019 to a new site at Victoria Avenue, Catterbourne. The current site is state land leased to MJTI Properties Company Limited. Cabinet approved a lease agreement between MJTI Properties Company Limited and the Municipal Council of Catterbourne for an area of 5,200 square meters square at an annual rental of 1.1 million rupees. The fair has been operating at this location since its relocation. I wish to assure the honourable members that my ministry is actively following up on this project as a matter of priority. We are treating it on a fast-track basis and giving it due consideration to ensure that all administrative and procedural steps are completed promptly so as to facilitate the development of a permanent market infrastructure for the benefit of traders and community. It is regrettable that, despite the site being operational since 2019, no significant progress was made by the previous administration to secure the required land vesting or to move forward with construction. Procedures are now being accelerated to transfer the land from the State Investment Corporation to the Ministry of Housing and Lands, which will then vest the land with my ministry. Currently, 5,400 meters square of the site is being used as a bus holding area on weekdays and Saturdays, and as a market fair on Sundays. According to correspondence dated 20 March 2025, the State Investment Corporation has returned the leasehold rights to the Ministry of Housing and Land. Compensation has also been agreed for construction structures on the site covering an area of around 6,000 meters square. The Victoria Fair currently consists of 277 stalls across various sections, including vegetable, food, haberdashery, flowers, egg, fish, and spice. Of these, 232 stalls are occupied while 45 remain vacant. The fair operates on Sundays only from 6 o'clock to noon. Police assistance is provided during operation to regulate traffic and hawking activities. Basic facilities including toilets for male, female, and disabled persons are available. Parking is also provided at the nearby Magi Marut Activity Center. It is unfortunate that the previous government, also 2 million rupees had been earmarked for consultancy services as far back as 2021. Two separate procurement exercises were launched, one in 2021 and another one in 2022, both of which failed due to poor planning and lack of responsiveness. No meaningful action was taken after that. Despite the allocation of 70 million rupees in the public sector investment program over several years, construction never started. The current administration in office since November 2024 has taken decisive steps to release the project. A design and build approach was approved by the Council's Executive Committee, and the Public Infrastructure Department has finalized the project specification. However, works can only begin once the land is officially vested. My ministry is working diligently with all concerned institutions to expedite this final step and initiate construction without delay. The absence of meaningful progress in this essential infrastructure over the last 5 years highlights the delays and inaction of the previous regime. The new government is committed to change this situation and to deliver a permanent, well-equipped and dignified marketplace for our traders and the community over there.
Yes. Supplementary.
Je vous remercie, Monsieur le Vice-président. Can the Honourable Minister inform the House why, despite the allocation of 70 millions de rupees in the last budget, construction has still not started?
As I just said, Mr. Deputy Speaker, sir, although the 70 million rupees has been earmarked in the budget 2024-2025 for the construction of the permanent market, the project is still awaiting completion of the land vesting procedures. Procedures are only now being accelerated to transfer the land from the State Investment Corporation to the Ministry of Housing, which will be then vest the land with the Ministry of Local Government within 2 months.
Okay,
Thank you, Mr. Deputy Speaker. Given that only 232 out of 277 stalls are currently occupied, would the Minister inform the House what measures are being taken to support the vendors and ensure full occupancy of the remaining spaces?
Yes, Deputy Speaker, sir. In fact, an expression of interest was launched on 17 March 2025 to allocate the remaining 45 stalls, with a closing date which was set on 18 April 2025, and the evaluation process is currently undergoing.
Thank you. The Honourable First Member for Porty North, Mount Island.
Thank you, Mr. Deputy Speaker. B428.
Minister.
Mr. Deputy Speaker, sir, I am informed that on 5th May 2023, the State Trading Corporation STC launched an open international bidding exercise for the supply of white oil for the period of 1st August 2023 to 31st of July 2024. At opening of bids on 26 May 2023, 7 bids were received, wherein the lowest offer was from OQ Trading Limited. On 7th of June 2023, the Board of STC approved that the contract for the supply of white oil for the period of 1st August 2023 to 31st of July 2024 be awarded to OQ Trading Limited, the lowest substantially responsive bidder. I am further informed that prior to the award of a contract, the STC received a direct offer from Mercantile and Maritime Holdings WLL, offering lower premiums on all 4 categories of white oils products and several competitive advantages according to the then STC board and the then government. Following the due diligence done by the STC and the then government, the contract was awarded to the Mercantile and Maritime Group. Mr. Deputy Speaker, sir, I wish to inform the House that a few days ago, at their request, I met with the 2 representatives of OQ Trading Limited in presence of my PS, my permanent secretary, wherein they informed of disturbing facts with regards to the above-mentioned procurement exercise. This is a matter of concern and gives rise to many doubts regarding the way things were done under the previous government. This gives additional justification as to why a few months ago government had requested that the Financial Crimes Commission, FCC, investigate the whole process. In parallel, I have already instructed for an audit exercise to be carried out at the STC, and in particular on all major procurement exercises done for the last 10 years. Mr. Deputy Speaker, sir, with respect to the above-mentioned direct procurement exercise for petroleum products from Mercantile and Maritime Group, I am advised that the whole procurement process is currently under investigation by FCC. In this regard, I stand advised that it would not be appropriate to disclose the requested details at this stage so as not to prejudice the integrity of the ongoing investigative process. B. In addition, given the ongoing FCC investigation, any tabling of contractual documents is deferred pending the outcome of a said inquiry. I wish to assure the House that my ministry and the State Trading Corporation are fully cooperating with the relevant authorities and stand committed to upholding transparency, accountability, and the rule of law.
Thank you. The Minister stated that there is an inquiry of the FCC, and we don't want to prejudice the inquiry. If you can put your question, but then the Minister will decide whether he wants to answer or not.
Yes, the Honourable Minister will remember when he was sitting in opposition that this was the subject of the private notice question at the time for making public the contract. And the financial cost to this day has never been made public. Forget the contract, the financial cost. So can the Minister at least, like the question asked, give to the people of Mauritius an indication as to the financial cost of this contract? How much was the contract value for? Whether it was for the acquisition of petroleum product together with the transport and other costs, and what was the amount for that? We have a right to know.
Mr. Deputy Speaker, sir, I believe that the contract was amounted to almost 30 billion rupees.
Mr. Deputy Speaker, I have heard the Honourable Minister referring to disturbing facts while he had a meeting with the representatives of OQ Trading. For the benefit of this House and the whole nation, can he tell us what he meant by disturbing facts?
Monsieur le Vice-président, quand j'ai rencontré les 2 représentants de OQ Trading Limited, j'étais choqué. Ce que les 2 représentants m'ont confirmé, ils m'ont dit qu'il y a eu quelqu'un qui a pris contact avec eux depuis Dubaï. Ils ont demandé de l'argent en échange Et je suis content d'avoir eu cette question pour que je puisse répondre. Et puisque OQ Trading n'a pas accédé à la demande de cette personne, malheureusement, il n'a pas eu le contrat.
The Deputy Speaker, sir, I wish to ask the Minister whether it is an established or admissible practice to set aside a tender exercise and go for direct bidding, however low the offer may be in the history or in the usual practice at the STC.
Mr. Deputy Speaker, this is not a good practice. As we know how the previous government was working, everything was possible with them.
Just one last question. One last question.
Mr. Deputy Speaker. Mr. Deputy Speaker, may I ask the Honourable Minister, in the name of change, does the Minister now undertake? Do you now undertake? Does the Minister now undertake? Because he has said, because of an inquiry, he cannot make it public, even though a few months ago he had himself requested that.
What's your question?
The question is, in the name of change, does he undertake to answer parliamentary questions for future contracts for the acquisition of petroleum product and to give all details and not to rely to hide behind confidentiality clauses? Do you give that undertaking?
I cannot give undertaking or whatever. I will answer whenever it is possible to answer.
Okay. The Honourable Third Member for Montagne Blanche and Condrieu-Sud-Est.
Thank you, Mr. Deputy Speaker. B429.
Thank you, Mr. Deputy Speaker, sir. I am informed that recurrent traffic congestion occurs along Belmar, Trou-de-Douce Road, B59. At Trou-de-Douce for the following reasons. Number one, commercial buildings have been constructed along B59 road, but it is to be noted that parking facilities have not been provided. On-street parking have been observed despite the presence of yellow lines. This is a recurrent feature in highly built-up areas with lack of adequate parking facilities, not enough enforcement by local authorities and the Mauritius Police Force results in even meager parking facilities being taken up by illegal structures, thereby leading to recurrent on-street parking. I am further informed, Mr. Deputy Speaker, sir, that with a view to relieving the traffic congestion at Trou-de-Douce, the Traffic Management and Road Safety Unit of my ministry has, as a short-term measure, provided single and double yellow lines at the village of Trou-de-Douce near RCA School and MCB to prohibit inconsiderate on-street parking. Mr. Deputy Speaker, sir, for the long term, the following measures are being proposed. Number one, to the District Council of Flacq to ensure that all requirements of planning policy guideline with regards to parking provision are met prior to issue of building and land use permit. Number two, the police should ensure strict enforcement. And number three, the District Council of Flacq should ensure that parking facilities are provided for development projects. Thank you.
Yes, the Honourable Second Member for Belrose-Cadbon.
B430.
Mr. Deputy Speaker, sir, I wish to inform the House that the financial statements for financial year 2015, that is January 2015 to December 2015, were tabled at the National Assembly on 24th November 2024. Regarding the financial statements for financial year 2016-2017, the statements have been audited and finalized recently by the National Audit Office. Same has been transmitted to the Clerk of the National Assembly last week for tabling. Mr. Deputy Speaker, sir, as I stated in my reply to PQ B66 earlier this year, instructions were given to the National Transport Corporation to expedite finalization of pending accounts, and the new board of the NTC was entrusted with the responsibility to ensure that all accounts be finalized and audited as a matter of priority. Mr. Deputy Speaker, sir, I am informed that necessary actions were taken by the board of the NTC, and subsequently the final statements for the remaining years that is 2018 to 2024, have already been prepared and submitted to the National Audit Office for auditing. I am further informed that the accounts for the financial years 2017-2018 and 2018-2019 are currently being audited by the National Audit Office, and the auditing of the accounts for the remaining financial years 2019 to 2024 will follow. The audited financial statements will thereafter be tabled to this August Assembly after completion of the exercise. Mr. Deputy Speaker, sir, regarding the final situation of the NTC, I have to inform the House that the last 3 reports audited by the National Audit Office were all provided with a qualified opinion, meaning that the completeness and accuracy of the information submitted by the NTC could not be ascertained by the National Audit Office, inter alia, regarding the inventories, the cash and cash equivalents, the property, the plant and equipment, and the trade and other payables. I invite the honourable members to consult the financial statements tabled so far, should they require additional information. Mr. Deputy Speaker, sir, it is a matter of great concern that the NTC has been accumulating deficits year on year since 2015 to reach a staggering sum of 1.223 billion rupees in June 2024. I can list the breakdown, but you will surely stop me, but let me just mention the last 4 figures where they are the highest. June 2021, ending June 2021, 199 million rupees. June 2022, 150 million rupees. June 2023, 184 million rupees. June 2024, 209 million rupees. And these are not audited figures. These are from management accounts. There could be more. These figures speak definitely for themselves on the state of the affairs of the corporation, which have been persistent over the last 10 years due to various reasons, including a poor management and a lack of appropriate strategies. It is against this backdrop that the new board of the NTC, under the chairmanship of Mr. Nishad Beg, held, I am informed, the very first strategic meeting on Saturday, 19 April 2025, with senior management people and board members of the NTC to strategically reflect on cost efficiency measures. Thank you.
One question.
Merci, Monsieur le Vice-président. Devant une telle dérive financière, je ne peux me taire. Est-ce que le ministre pourrait indiquer à la Chambre quelle action concrète son ministère prévoit-il face à ce déficit de 1 milliard à la NTC devenu clairement insoutenable? Merci.
Basically, cost-cutting measures. I had to mention the figures of the last 4 years because it is during those 4 years specifically that fake spare parts were bought at very high prices and were made to be passed for genuine spare parts and costed hundreds of millions of rupees to the NTC. So when you deal with fake spare parts, it means that you have to change it again because the quality is not the same. So cost-cutting measures, and even for tires, I had mentioned before, they were buying tires that lasted only 4,000 kilometers. Can you imagine? So the FCC is currently inquiring on this. I hope light will be shed sometime soon so that those responsible for this very sorrow state of affairs be made answer to the people of this country.
Yes, thank you. The Honourable First Member for Savadan Black River.
Thank you, Mr. Deputy Speaker. B431.
Mr. Deputy Speaker, sir, this information is being compiled by the NLTA, and I shall arrange for same to be placed in the library of the National Assembly once the same is made available to my ministry. Thank you.
The Honourable Second Member for Rivière-des-Orgues.
Thank you. Question B432, please.
Mr. Deputy Speaker, sir, at the level of my ministry, the prices of essential commodities on the market are continuously being monitored and analysed since importers and local producers are practicing significantly higher prices than usual. As regards the imposition of a maximum retail price on frequently consumed commodities, For Mauritius and Rodrigues, a survey is ongoing on different types of canned foods and other daily products. Based on the report that is expected shortly, I shall make a recommendation on the proposed extension of maximum retail price and other consumed commodities for consideration at the level of Cabinet prior to promulgating the regulation under the Consumer Protection, Price and Supplies Control Act 1998. A communiqué will thereafter be issued to the members of the public. Mr. Deputy Speaker, sir, according to Section 11 of the Legal Metrology Act on Labelling and Standardization of Pre-packed Commodities, no person is allowed to pre-pack any commodity unless the package of the commodity should bear a conspicuous label carrying declaration to prescribe inter alia. 1. The name of the commodity. 2. The net quantity of the commodity. 3. The name and complete address of the packer. And 4. Such other information as may be required. In addition, in line with the Consumer Protection, Pharmaceutical Products, Maximum Markup, Regulation 2023, importers are required to affix the approved maximum retail prices on every packet or container of pharmaceutical products. This concerns about more than 7,000 medicines which are subject to price control. As regards for other commodities, in accordance with the Consumer Protection, Consumer Goods, Maximum Markup Regulation 1998, a weighted average maximum price is applied to new consignment and existing stock. As such, the prices of the controlled commodities automatically change once the price in the new consignment is approved in order to reflect the new prices. Presently, consumers have access to transparent and necessary information on the newly approved maximum price for each product, which are on the website, the price fixing information system, and that are to be practiced by retailers. Consumers can thus also report for any mispricing to my ministry for necessary action.
Yes.
Can the Honourable Minister come up with regulations so that the MRP, the maximum retail price, be affixed, be visible to the consumers, so that at least they don't have to go on the website of the ministry to cross-check the MRP and the actual price that is being practiced in shops, supermarkets, and so on. And it is being practiced in India.
We will try to consider.
Thank you. The Honourable Second Member for Mayberg-Mayo.
B433.
Honourable Minister of Housing.
Mr. Deputy Speaker, sir, I am informed by the New Social Living Development Limited that out of 8,000 housing units, 688 houses, including on-site and off-site infrastructure works, have been completed over 4 sites, namely at Valletta, Olivia, Grand Bel Air, and Mar d'Albert. As such, the percentage completion of the 8,000 housing units project stands as at date at 8.6%. According to the NSLD, 6,642 additional housing units are expected to be completed over 31 sites by July 2026, which would bring the completion rate to 92% by the end of the next financial year. So obviously, Mr. Deputy Speaker, sir, the facts, the figures are there for all to see. It is this government that has to oversee the whole project of the 8,000 houses or so. The remaining 670 housing units are expected to be completed before the end of 2027. Mr. Deputy Speaker, sir, the completion of the 8,000 housing units project has been hampered due to delay in the implementation of off-site infrastructure work, clearly poor management, such as water and electricity supply, construction of drains, again, crazy poor management, unimaginable, and construction of appropriate sewage disposal systems. The sewage disposal part is even worse in terms of mismanagement. The NSLD is holding regular follow-up meetings with the authorities concerned and has taken over the implementation of immediate off-site drain works so that the housing units may be delivered to the eligible beneficiaries without any further delay.
Members, Minister, as we all know that all these social house has been constructed without all amenities, can the Honourable Minister table the list of contractors that has been appointed for the construction of these social housing units?
I have no objection to the needful. I do not have the required information at hand, but I will undertake to table it as soon as possible. As soon as possible.
Yeah. Honourable members, the table has been advised that the following PQs have been withdrawn: B435, B442, B445, B457, B452, and B455. Next question, Honourable Third Member for Rabé Prudo.
Thank you very much, Honourable Member. Mr. Deputy Speaker, currently there are only 2 bilateral fisheries partnership agreements in force, and these are related to tuna fisheries, namely a sustainable fisheries partnership agreement with the European Union, and the agreement was signed between the European Union and Mauritius on the 21st December 2013 and entered into force on the 28th January 2014 for a period of 6 years. It is tacitly renewable for an additional period of 3 years. Now, the countries concerned in this agreement are European member states. Mr. Deputy Speaker, as regards part A2 of the question, in respect of the condition attached thereto, I've been informed that the agreement provides for conditions to ensure sustainable exploitation of tuna resources in the waters of Mauritius. There are namely obligation of EU vessels to comply with the laws of Mauritius and to be included in the Indian Ocean Tuna Commission record of authorized vessels and not on the illegal, unreported and unregulated lists of IUTC or any other regional fisheries management organization. B, reporting of catch through submission of paper and electronic logbooks. C, notifying the Ministry on landing and transshipment activities of the vessels. D, notification on entry and exit of EU vessels from Mauritius waters. E, inspection and control of EU vessels by Mauritian inspectors. And F, regular reporting of fishing position through satellite-based vessel monitoring system. J, embarkation of observers to collect data on the fishing activities of EU vessels. And H, embarkation of local qualified seamen on board EU vessels. Now, the second agreement is a fishing agreement with the Federation of Japan Fisheries Cooperative Association. And this agreement was signed in 2007 and provides for the licensing of 50 Japanese longliners annually for longline tuna fishing in Mauritian waters. The agreement was first reviewed in 2009 and is automatically renewed for a further period of 2 years. However, the last licenses issued in respect of Japanese vessels were in 2019 and no new licenses have been issued. Now, the catch data from the Japanese vessel is also nil since the signature in 2007. In this respect, I intend to impressed upon our ambassador, the ambassador extraordinary and plenipotentiary of Japan, to reboost the agreement so that more Japanese vessels can fish in our waters. The conditions under the agreement are the same in relation to the agreement which we have with the European Union. Now, Mr. Deputy Speaker, as regards Part B of the question, I wish to inform the House that tuna are migratory fish and exhibit significant migratory patterns driven by factors like feeding, spawning, and seasonal currents, and travel extensively among EEZ found in the Indian Ocean. The Indian Ocean Tuna Commission is the regional fisheries management organization responsible for sustainable management of the tuna and tuna-like species in the Indian Ocean. It is also responsible for the stock assessment of the tuna species, which are carried out on a regular basis. Mauritius is party to the Indian Ocean Tuna Commission and adheres to all the conservation and management measures put forth by the Indian Ocean Tuna Commission. Other than tuna, Mauritius also had the bank fisheries in which demersal species are caught by semi-industrial fishing vessels that bring chilled and frozen fish to the Mauritian population. It is well-established fishery and stocks, it is a well-established fishery and stocks, and these are monitored regularly by the Albion Fisheries Research Center.
Yes,
Deputy Speaker, sir, can we have some details on the financial aspects of the agreements to the EU and the Japan? The financial aspects.
No, I don't have the information, but I can retrieve the information and submit accordingly.
The Honourable Third Member for Bobassa Chitkir.
B436.
Mr. Deputy Speaker, I wish to inform the House that on the 24th April 2025, the Mauritius Olympic Committee has forwarded to me a copy of a letter dated 16 April 2025 from the International Olympic Committees that was addressed to the President and members of the Executive Committee of the Mauritius Olympic Committee. The said letter, the International Olympic Committee, inter alia, raised concerns about the situation prevailing at the Mauritius Olympic Committee and pressed upon the latter to take all necessary measures to ensure the holding of the elective General Assembly at the earliest opportunity, failing which the International Olympic Committee may take protective measures in line with Rule 27.9 of the Olympic Charter, which includes suspension of or withdrawal of recognition from a National Olympic Committee. In this case, the Mauritius Olympic Committee, Mr. Deputy Speaker, I'm informed that the elective General Assembly of the Mauritius Olympic Committee was scheduled on 25th January 2025. However, on 23rd January 2025, upon an application by the Mauritius Tennis Federation, the Sport Arbitration Tribunal ordered that an interim order in the nature of an injunction be issued restraining and prohibiting the Mauritius Olympic Committee from holding or proceeding with its forthcoming elective General Assembly pending the hearing and determination of the present matter. While the case was still ongoing before the Sport Arbitration Tribunal, the Mauritius Olympic Committee scheduled another elective General Assembly for 29th March 2025. On 20 March 2025, following an ex parte application by the Mauritius Tennis Federation for an ex parte interim order, the Sport Arbitration Tribunal declined to issue the order as the latter understood and recognized that parties are to maintain the status quo pending the hearing and determination of the main case. Thus, the application was set aside. I'm informed that in face of this new development, the Mauritius Tennis Federation applied for an injunction before the Supreme Court, and the same was granted. An application by the Mauritius Olympic Committee to discharge the injunction was set aside. I'm further informed that the Mauritius Olympic Committee has appealed against this decision, and the case is ongoing before the Supreme Court. Mr. Deputy Speaker, notwithstanding the aforesaid mention, I had already written to the International Olympic Committee as far back as 21st March 2025 to draw their attention to governance issues that were prevailing at the Olympic Committee. Mr. Deputy Speaker, further to the International Olympic Committee's letter dated 16 April 2025, I have addressed another letter to the said committee informing them that the present situation is due to internal conflicts among the members of the Mauritius Olympic Committee and not due to some form of government interference. I expressly made reference to the fact that under our legislation, national sport federations are autonomous bodies that are free to operate within our republic so long as they have a legal status and comply with the Olympic Charter. I also stated this government firm commitment to collaborate with the International Olympic Committee to ensure free and fair election at the level of the Mauritius Olympic Committee.
Yes.
Avec votre permission, par rapport au contexte actuel, le ministre peut-il nous dire comment il compte éviter au pays une suspension, alors que le CIO, dans le passé, n'a pas hésité à suspendre de grandes nations comme l'Inde et la Russie? Ça, c'est ma première question, Monsieur le Président.
Mr. Deputy Speaker, sir, this is a speculative question. We shall cross that bridge when we come to it. As far as we are concerned, we are proceeding accordingly to our legal framework. As I have stated in my reply, the matter is sub judice and we have to respect our code of law.
L'honorable ministre ne pense-t-il pas que c'est de son devoir de réunir le COM, la Fédération mauricienne de tennis, le représentant du Comité olympique international, s'asseoir avec l'honorable ministre lui-même et ses officiers pour trouver une solution à ce problème. Parce que ce que nous risquons, Monsieur le Vice-président, c'est de voir nos athlètes être pénalisés. C'est cela mon souci. Je connais très bien comment ça se passe. Je ne suis pas là pour dire qui a raison, qui a tort. Mais ma question est justement de demander au ministre de réunir tout ce beau monde, de s'asseoir et faire de son mieux pour qu'on puisse arriver à une solution, évitant ainsi que le pays, c'est le pays qui sera suspendu et les athlètes mauriciens avec. Oui, ben justement.
Honorable Deputy Speaker, I'm really surprised because at this stage, like I mentioned, it is not appropriate at all to meet with parties as there is an ongoing court case. There is an ongoing court case. So how can we meet with these people? You yourself in the past, you mentioned that. You criticize that. And today you are telling me to meet with people who is using dirty money? Up to you, but not me.
Next question. We go to your next question. Your next question, B437.
Sorry?
We are going to your next question. You have a next question?
No, I have one last question.
Okay, I'll do one last one.
Yes. Monsieur le vice-président, je connais très bien la situation et je sais très bien comment ça se passe. Je ne suis pas en train de défendre ceux qui sont en train de finir le sport à Maurice. Au contraire, ma question est, si certains n'ont pas compris ma position, et ma position, elle n'a jamais changé, même quand j'étais dans l'opposition, avec mon parti, et qu'aujourd'hui je suis un indépendant, ma position reste la même. Il faut mettre de l'ordre dans le sport, je suis d'accord, mais je demande à ce que les athlètes ne soient pas pénalisés. Il faut trouver une solution. Je ne suis pas là pour dire qui a raison, qui a tort. Je laisse le soin à l'honorable ministre. C'est lui le ministre, c'est à lui de prendre les bonnes décisions, je reconnais. Mais je demande... Ma question est, est-ce qu'on... L'île Maurice doit s'attendre à ce que dans les jours à venir, est-ce que le mouvement sportif peut s'attendre dans les jours à venir à ce qu'une solution soit trouvée afin que le sport mauricien ne soit pas pénalisé, suspendu par le CIO. C'est ça mon souci.
I'm going to repeat myself, Deputy Speaker. The thing, all the situation is before the Court of Justice. So we have to wait.
Okay, next
we
question.
Have to wait. There is nothing else that we can do.
I'm doing my job.
Next question, B437, Honourable Third Member for Bobassa.
B437, please.
Mr. Deputy Speaker, sir, with the increasing prevalence of social media platforms such as Facebook, Instagram and TikTok being used for commercial transactions, my ministry has noted a significant rise in complaints concerning misleading advertisements, unfair trading practices and a lack of transparency in dealings with online sellers. In response to these concerns, the Fair Trading Act has been amended to empower my ministry to formulate specific regulations governing electronic commerce, including activities conducted via social media platforms. Accordingly, Mr. Deputy Speaker, sir, my ministry has initiated the drafting of the E-Commerce Regulations 2025, which aim to introduce a robust legal framework for regulating the sale of goods and services over digital platforms. These regulations will cover all forms of online trading in Mauritius, including those conducted through social media. Formal consultations on the draft regulations commence on 12 February 2025 with key public sector stakeholders. These were followed by a second round of consultation on 10th April 2025 with representatives from the business and consumer sectors, including the Mauritius Chamber of Commerce and Industry, MCCI, the General Retailers Association, GRA, and the Association des Consommateurs de l'île de Maurice, ASIM. These stakeholders were invited to review and submit proposals on the preliminary draft. Mr. Deputy Speaker, sir, these regulations will apply to all e-commerce activities within the Republic of Mauritius and are intended to protect consumers while ensuring that all traders, including those operating on social media, adhere to fair and transparent practices.
Vice-président, avec votre permission, concernant les produits contrefaits qui sont vendus en ligne, l'honorable ministre peut-il nous dire quelles sont les mesures qu'il compte apporter afin de protéger les consommateurs?
Well, we will definitely look into it.
Thank you. The table has been advised. Remember, the table has been advised that the following PQs have been withdrawn. B439, B453, B458, B450, B459, B449, B456, B460, and B446. Now the Honourable Second Member for Grand-Bienne pour the law.
Thank you, Mr. Deputy Speaker, sir. B438.
Mr. Deputy Speaker, sir, I wish to thank the Honourable Member for this PQ, which will allow me to expound on the new philosophy of this government regarding amenities of government schools. In fact, I'm informed that some of the amenities of government schools were already accessible to the public prior to my coming into office. However, given that there are numerous requests from registered organizations to benefit from government school amenities, my ministry has decided to provide more access to the following amenities. 1, gymnasium for badminton. 2, football grounds, volleyball and basketball pitches. And 3, classrooms to conduct workshops on human values, anti-bullying campaigns, and training by registered agencies to empower our senior citizens and women's organizations. It has been reported that there are no appropriate amenities in many localities for the public to practice activities such as karate, yoga, and Zumba, among others. With a view to providing such leisure activities in different localities, with a primordial antidote for drug and substance abuse, the public will be given access to the above activities in more government schools in light of emerging needs and requirements. Mr. Deputy Speaker, sir, as per the existing procedures, registered groups or organizations have to submit their applications to the head of school or to the zone directorates. Same are approved by the zone directors upon the recommendation of the head of school for a period valid up to 4 months, subject to availability of slots. There is a payment of a nominal fee of 100 rupees per hour for badminton courts and 200 rupees per hour for whole gymnasium and football ground. The nominal fee is used to cover the cost of maintenance and security service for the amenities. With a view to maximizing safe and secure access to government school amenities for extracurricular activities after school hours, the current procedures will be streamlined and the fees to be charged will be reconsidered. The amenities of schools will be granted to registered organizations in the locality and its surrounding areas. A survey across all schools having such amenities will be conducted, and same will be put at the disposal of the public. However, this will entail a responsible use of these amenities. Those who will be using the school premises will have to adhere to strict discipline, rules and regulations, which will be set by the heads of school and zonal directors. In no way should our staff or students be penalized or disturbed by this measure. I wish also to reassure educators and head of schools that opening the premises of government schools after school hours for extracurricular activities will not entail any additional hours of work for them. Thank you.
Thank you. Time is over. The table has been advised that PQB 441 has been withdrawn.
Motion.
Honourable Prime Minister.
To move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
The question is that all the business on today's paper order be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye, those against say no. The ayes have it. First reading.
Statement by Ministers none. Public Bills first reading.
Mr. Deputy Speaker, I beg to move that the Constitution Amendment Bill number 10 of 2025 be read the first time.
Seconded.
Mr. Deputy Speaker, sir, I beg to move that the Criminal Code Amendment Bill number 11 of 2025 be read the first time.
Honourable members, Madam Speaker will take the chair.
may be seated.
Public Bills, second reading.
Yes.
Madam
Yes,
Speaker,
Honourable
I
Minister.
stand up and, I move that the Public Inquiries Bill number 5 of 2025 be read a second time, and I stand as Acting Attorney General in this matter. Madam Speaker, the Public Inquiries Bill is not a routine update or a cosmetic change of name, the same old product in a new packaging. This is a reform of our whole approach to administrative inquiries, a reform whose time has come and whose necessity is both practical and historical. For this bill is about how the state confronts the truth, how it learns from experience, and how it responds when something has gone wrong or is feared to have gone wrong. As honourable members are aware, the Government Programme 2025-2029 has pledged to replace the Commission of Inquiry Act of 1944 with a legislation that is modern, transparent and fit for purpose. Indeed, Madam Speaker, the Act it replaces is over 80 years old. It was shaped in a colonial era when the Governor-General, not Parliament, determined how and why inquiries would be held. It contains no procedural safeguards, no timelines, no recognition of rights, and no clarity as to the legal status of findings. Over time, it has become a blunt tool, sometimes used well, sometimes not. In a modern democracy, we need more coherent standards, less confusion. We need a sharper instrument, one capable of balancing truth-finding with fairness and legitimacy. This is why we are now replacing a bludgeon with a scalpel. The flaws of the old law are well documented. Commissions of inquiry have too often lacked credibility, not necessarily because the idea of truth-finding was wrong, but because the process failed. Our courts have thus intervened repeatedly. In the case of Ramgoolam versus Matadin 2001, the Supreme Court criticized the Commission for making serious allegations against the sitting Prime Minister without giving him a chance to respond. In Valaiden versus Matadin 2002, it found that individuals were denied the right to rebut damaging evidence heard in their absence. There have been many such examples over the years. In fact, it is now expected that after the publication of every report by a Commission of Inquiry, there will be applications for judicial review, where people affected by damaging comments would go to the court to seek justice. They would say, my rights were violated, my reputation has been damaged, I was not given the chance to rebut allegations against me, I was not treated fairly. And regularly the Supreme Court has vindicated them. In 2022, even the Privy Council found, in the case of Payendi versus Lam Shanglin, that, I quote, the procedure adopted by the Commission in relation to the appellant did not accord with the principles of fairness and natural justice, unquote. The courts have been clear. Natural justice is not optional. Fairness is not negotiable. Where rights and reputations are at stake, due process is a must. An inquiry's legitimacy depends not just on what it says it has uncovered, but how it went about to uncover it. This is not merely a philosophical point, it has practical implications. The Institute for Government in the UK has shown that public trust in the inquiry process is tightly linked to transparency, timeliness, and clarity of purpose. In their study of UK public inquiries, they note that delays, vague mandates, and political interference have all undermined effectiveness. Similarly, in Australia, the Institute of Public Administration reported that inquiries fail when they become vehicles for blame rather than instruments of institutional learning. New Zealand's Law Commission also warned of the dangers of inquiry structures that lack coherence. In its 2008 review, it noted there was no consistent approach in the establishment, management, or conduct of inquiries at the time. It recommended greater codification, better rights, protections, and clearer rules of procedure, many of which mirror the features of the bill now before this House. Dr. Scott Prasser, a leading academic in the field, has written extensively on the need to avoid inquiry inflation, where an ad hoc inquiries proliferate without consistency, leading to public fatigue and institutional confusion. He stresses that inquiries should be exceptional events, not routine political reflexes. This bill embodies that ethos by placing structure and procedure where there was once opacity and confusion. Madam Speaker, at the core of this bill lie three essential objectives: to enhance transparency, ensure procedural fairness, and strengthen the legal foundations of public inquiries in Mauritius. First, the bill enhances transparency and accountability by mandating that inquiries be held in public unless justified exceptions apply, and by requiring that final reports be published and tabled in the National Assembly. It ensures that the public is kept informed of matters of significant national concern. This will foster trust in the process and confidence in the institutions involved. Second, the bill safeguards procedural fairness. It provides a structured, rights-respecting framework for how inquiries are to be conducted. Individuals whose rights or reputations may be affected are explicitly granted the right to be heard, to present their version of events, and to respond to allegations. Third, the bill consolidates and clarifies the legal framework governing inquiries. It codifies the powers, responsibilities, and limitations of boards of inquiries. Of the boards of inquiry. This removes ambiguity, reduces the risk of politicization or procedural error, and provides a clear roadmap for all actors involved, from the appointing authority to those summoned to appear. In so doing, it modernizes our public law architecture in a way that is aligned with modern democracies. Madam Speaker, let me now turn to the main features of the bill which are designed to achieve these objectives. Under Clause 3, the Prime Minister may establish a board of inquiry where he considers that a particular event has caused or may cause public concern, or that there is significant public concern that such an event has occurred. This ensures inquiries are initiated where there is a genuine need for institutional scrutiny, grounded in the public interest. This approach is consistent with international models. In the United Kingdom, inquiries under the Inquiries Act of 2005 are set up by a Minister of the Crown. In Australia, similar discretion is vested in the executive. The principle is the same. Inquiries are initiated by elected leaders who are accountable to Parliament and to the electorate for their decisions. What matters is not just the identity of the initiator, but the framework of transparency and oversight that surrounds that prerogative. In our case, this is addressed through Clause 6, which requires the Prime Minister to notify the National Assembly once a board has been or will be set up. Clause 21 provides that the Board of Inquiry must submit its report to the Prime Minister upon completion of its work, and Clause 22 then mandates that the report be tabled before the National Assembly and published within 30 days. This avoids the common problem of reports being shelved or selectively disclosed, and reinforces the duty of accountability to Parliament. The imposition of a deadline to submit a report in Clause 5 will be an important break from the past. No longer will reports be left dans les tiroirs de qui que ce soit. Clause 4 requires that every board of inquiry operate under clear, defined terms of reference. These will set out the subject matter, scope and timeline for the inquiry to further strengthen independence and clarity. Clause 8 provides that the Prime Minister must consult the appointed chairperson before finalizing the terms of reference. This consultation ensures that the person responsible for managing the inquiry has the opportunity to shape its mandate and is not merely handed a political script that he must follow. Subject to exceptions for confidentiality or public interest, proceedings are to be held in public. Members of the public, including the press, may access the proceedings and view the record of evidence. This not only builds legitimacy, but also guards against selective leaks, secrecy, and political misrepresentation. As we have seen, a central weakness of the 1944 Act was its silence on individual rights. Clause 18 corrects this. Any person who reasonably believes that their reputation may be adversely affected by the inquiry is entitled to be heard and to give evidence in rebuttal. This codification, Madam Speaker, this codification of natural justice is one of the most critical features of this bill. It mirrors the so-called Maxwellisation process in UK law and directly addresses the recurring procedural failings that led to so many court decisions. Clause 5 draws an important line. A board of inquiry may not make a binding determination on civil or criminal liability. It is not a court of law. It does not pronounce guilt nor impose sanction. However, Clause 5.2 rightly clarifies that the board may still draw inferences based on the evidence it has gathered and may make recommendations. That is the nature of any investigative process, to form a view on the facts. This is no different from the position under the UK Inquiries Act of 2005, where inquiries are similarly prohibited from making formal legal findings, but may report on facts that point to misconduct or wrongdoing. This balance is essential, Madam Speaker. It protects individuals from judgment without trial, while allowing the state to learn, to recommend, and where necessary, to refer matters to the proper legal or disciplinary authorities. The bill preserves the right of judicial review. As per Clause 30, anyone aggrieved by the findings of an inquiry may seek redress through the courts within 21 days. This ensures that inquiry powers are subject to legal limits and that those affected have a clear procedural remedy where those limits are breached. Madam Speaker, let me be clear. Clause 32(2) provides that all pending commissions under the old law shall lapse. This will apply to the Commission of Inquiry on the affreightment of Betamax. The Betamax case has been the subject of a long and expensive litigation saga. An international arbitration tribunal, the Supreme Court, the Judicial Committee of the Privy Council have all examined the matter. And ultimately, the Privy Council found clearly that there was nothing improper about the contract. You cannot be clearer than that. Despite this, the previous government saw fit to establish a commission of inquiry into the very same matter targeting in particular the current Prime Minister. If you want to know what is politically motivated, learn from the other side. That commission serves no real purpose. It has no legal justification. Its political agenda was clear for all to see. It was simply an exercise in retroactive blame. It cannot be allowed to carry on and to further waste public money. Madam Speaker, this bill is not about shielding anyone from scrutiny. It is about ensuring that scrutiny is meaningful, lawful, and fair. It puts an end to a model that has too often confused inquiry with prosecution, or even persecution, and replaces it with a framework built on clarity, accountability, and justice. In doing so, we uphold the values of due process, institutional integrity, and the rule of law. I therefore commend the bill to the House.
Yes, Honourable Leader of the Opposition, the floor is yours.
Thank you, Madam Speaker, for giving me the floor to intervene on this piece of legislation. Madam Speaker, timing and context are always important factors to be considered whenever a piece of legislation is proposed in the National Assembly. Concerning this piece of legislation, Madam Speaker, I believe it is my duty as leader of the opposition to voice out my concerns. We have a fundamental issue with the presentation of this bill. And my first remark is very pertinent. As compared to the Commission of Inquiry Act of 1944, in this present bill, the Prime Minister is being given wide powers et une liberté sans limite par rapport à cette nouvelle législation. Madam Speaker, powers which this National Assembly had been given to the President of the Republic since we have become a republic today, unfortunately, these powers are being taken away from the President in this public inquiries bill. And I refer to two specific sections. First, Section 2 of the Commission of Inquiry Act on appointment of commissions of inquiry. And I also refer to Section 3 of the Commission of Inquiry Act entitled Powers of the President, and I refer particularly to Section 3.4, which says, and I quote, "Any commission may be altered or revoked by the President with the advice and consent of the Assembly or by the President as the case may be." Madam Speaker, under Clause 6 of this bill, the Prime Minister has a duty to inform the National Assembly only this time when setting up the Commission of Inquiry. This bill does not impose any duty on the Prime Minister to seek the advice and consent of this august Assembly. Madame la Présidente, c'est un recul pour la transparence et le devoir envers cette auguste Assemblée. Et cet après-midi, Madame la Présidente, nous allons voter une loi, et je pense que c'est une première, pour enlever les pouvoirs au Président en ce qui concerne la mise sur pied d'une commission d'enquête. Et nous savons tous, Madame la Présidente, qu'éventuellement, après avoir voté cette législation, c'est le Président qui aura donné son assentiment à cette loi. And I wish to refer the House, Madam Speaker, to Section 65 of our Constitution, where it is stated, and I quote, "The Prime Minister shall keep the President fully informed concerning the general conduct of the government of Mauritius and shall furnish the President with such information as he may request with respect to any particular matter relating to the government of Mauritius." À ce stade, Madame la Présidente, je voudrais savoir si le Président de la République a été consulté et s'il a donné son accord. Car au cas contraire, nous pourrions nous retrouver face à un refus du Président de la République de donner son assentiment à ce projet de loi et nous retrouver, comme en février 2002, face à une crise constitutionnelle au plus haut sommet de l'État. My second remark on this bill, Madam Speaker, refers to the mode of setting up the Board of Inquiry. Again, one would expect that the President of the Republic, given his duty in the Constitution as the head of state, that is to uphold and defend the Constitution and to ensure that the Constitution of democracy and rule of law are respected, the President of the Republic would be the proper person to establish such a board of inquiry. But it is not so anymore in the piece of legislation we are debating today. Instead, Madam Speaker, it is only where the Prime Minister is of opinion that in the public interest or public welfare that he would set up the Board of Inquiry. The President of the Republic, as the head of state, does not have his say anymore. He is only called upon under Clause 8.4 of the bill to preside only the swearing ceremony of the members of the Board of Inquiry appointed by the Prime Minister. Madame la Présidente, selon moi, le rôle du Président de la République dans notre démocratie est en train d'être bafoué avec ce projet de loi et je pense, comme je l'ai dit, que c'est la première fois que les pouvoirs du Président sont enlevés. Now, Madam Speaker, notwithstanding the preamble of this bill, one should ask this question: what is the true objective of this bill? And I hope, Madam Speaker, that it is not a political strategy against political opponents to the regime in the name of public concern or public interest. Madam Speaker, you will agree that the role of the National Assembly is also insignificant now in this piece of legislation. One would expect that there might be a board of inquiry in a democratic society where Parliament is involved. However, from now on, the Prime Minister will decide of the setting up of a board of inquiry as per Clause 3 of the bill. And with your permission, Madam Speaker, I would like to quote this specific Clause 3, that is, setting up of board of inquiry, where, and I quote, where the Prime Minister is of the opinion that A particular event has caused or is capable of causing public concern, or B, there is public concern that a particular event may have occurred, and as far as Clause 3A is concerned, on the wording of a particular event as caused, my question to the Prime Minister is there any prescription as to time? How far back in time can we go with this legislation, Madam Speaker? And here I wish to know is the Prime Minister, for example, of the opinion that the phone tapping scandal should be subjected to a public inquiry? And secondly, on the wording of is capable of causing, is that a wholly subjective test as to the Prime Minister's belief? Are we made to understand that the setting up of a board of inquiry rests upon the Prime Minister's capacity of preempting the future impact of a particular event? The same queries, Madam Speaker, applies to clause 3B concerning the wording that a particular event may have occurred. So are we made to understand that it may not have occurred, but the setting up of a board of inquiry will still be justified? Madam Speaker, clearly here, the Prime Minister is being given extensive powers to set up boards of inquiries at will, and therefore, through this legislation, will be the sole master with real-time follow-up, first, of all proceeding, and this is reflected in many clauses. Now, Madam Speaker, allow me to quote clause 7.2, which relates to suspension of an inquiry. The Prime Minister shall not later, and I quote, later than 7 days after the completion of any investigation or determination of any civil or criminal proceedings under subsection 1A or B, as the case may be, order the Board of Inquiry to proceed with its inquiry. With due respect, Madam Speaker, to our Constitution, we all know that civil or criminal proceedings take years to be fully determined. And so, during such time, the Board of Inquiry would be suspended or in limbo, if I may say. What if those, Madam Speaker, what if those civil or criminal proceedings, when finally determined, are unsuccessful and the targeted person or persons win the day? Should, in that case, the legislator not then impose upon the Prime Minister the fate of that Board of Inquiry? Maybe, Madam Speaker, in similar lines to what clause 4, that is terms of reference of Board of Inquiry, provides. Madam Speaker, also according to clause 7 of the bill, the two reasons provided under that clause for suspension, I believe, are not sufficient. They are restrictive, and the request of the board for suspension should be broadened to include any valid reason put forward by the board to request a suspension. At section 4.2, that is terms of reference of the Board of Inquiry, it is stated the Prime Minister may at any time amend the terms of reference of a Board of Inquiry in the public interest or for the public welfare. Est-ce que, je me pose la question, Madame la Présidente, est-ce que cette section spécifique ne rend-elle pas légale l'interférence politique dans le déroulement des travaux d'une commission d'enquête? Madame la Présidente, la séparation des pouvoirs est un principe sacro-saint au sein de notre République et notre système judiciaire a toujours été respecté. Mais cette section du projet de loi nous interpelle. Un Premier ministre va pouvoir interférer dans les travaux présidés par un sitting judge ou un ancien juge. Madame la Présidente, la section 4.3 fait référence aux consultations entre le président de la Commission et le Premier ministre avant tout changement au terme de référence. And I quote section 4.3, the Prime Minister shall, before setting up or amending the terms of reference of a board of inquiry, consult the person he proposes to appoint or as appointed as chairperson. Une question se pose. Que va faire le Premier ministre si le président de la Commission rejette cette demande de changement? Va-t-on à ce moment-là révoquer le président de cette commission? Alors, si c'est le cas, dans un tel cas, est-ce qu'on verra un ancien juge ou un sitting judge être révoqué par un Premier ministre? At clause 32, Madam Speaker, the bill provides that previous commission of inquiry, which is pending on the commencement of this act, should lapse. But curiously enough, at clause 3.3, it is envisaged that no board of inquiry shall be discontinued by reason of or otherwise affected by the Prime Minister's absence or by him ceasing to hold office, whether as a result of his death or for any reason. This is a blatant contradiction of the rationale behind the idea of maintaining the Board of Inquiries set up by precedent government as contemplated, Madam Speaker, in clause 3.3 of the bill. Madam Speaker, another issue which I want to bring to the attention of this House. We are in Mauritius. In clause 8.2b, which pertains to the composition of the Board of Inquiry, how close is close in the sentence a close association with an interested party? Maybe we should determine the definition of close firstly. The subpart B of the bill on evidence and procedure is quite elaborate. However, notwithstanding the restrictions in clause 14, under clause 13b, it would now be mandatory for the chairperson to take all reasonable steps as may be necessary to ensure that all members of the public are able to obtain or view a record of evidence given and documents produced or provided during such proceedings. Whilst this is expressly stated, I presume, Madam Speaker, that anyone being called by the Board of Inquiry will have the same entitlement, that is, to obtain or view a record of evidence given and documents produced or provided during such proceedings. Now, if this is the case, Madam Speaker, why not expressly say so in the bill? Madam Speaker, let me refer to clause 28.2 of the bill, and I believe our International Financial Center is potentially at risk with this clause. The Honourable Attorney General is making a use of the doctrine of implied repeat in clause 28.2 of the bill. Laws, Madam Speaker, such as the Banking Act, and more specifically, banking secrecy provided, for example, in Section 64 of the Banking Act, which are being impliedly repealed. Why not, in full transparency, tell this August Assembly which laws are being expected to be accepted in clause 28b? Why not have a specific clause in this bill on consequential amendments, as has been the cursus in this National Assembly? Madam Speaker, I sound this note of caution because our International Financial Center is potentially at risk. And I ask the question, has the Bank of Mauritius the Financial Services Commission, and the Mauritius Bankers Association being consulted. Madame la Présidente, je vais conclure. Le gouvernement apporte des gros changements par rapport à une des commissions les plus indépendantes de notre pays. Une complète révision du système et qui touche directement la présidence de la République et donne les pouvoirs au Premier ministre. J'ai fait des recherches et je n'ai pas vu d'autres lois passer dans cette auguste Assemblée après que Maurice soit devenu une république qui enlève les pouvoirs ou prérogatives donnés au président de notre République. Le peuple mauricien doit prendre bonne note de cet affaiblissement des pouvoirs du président. L'avenir nous dira si la nouvelle commission sera un outil politique ou une institution indépendante. Madame la Présidente, j'en ai terminé.
Merci. Je vous remercie. I think we could break for tea, if you agree.